and that concerns include Mini Cooper in the Michigan plate. If you are the owner of this vehicle, you're kindly requested to make yourself known to the organizers. That's it, you have to say it. So, now, building on to the morning sessions, we are here to talk about an angle that is perhaps a little more systemic and forward-looking on conference speaking. And in the next 1.5 hours or so, we will be hearing from our distinguished panelists issues, let's say, topics such as an overview of the international criminal justice institutions now in place, and impacts, consequences of their actions, problems, challenges, and prospects that these institutions face in the coming years. And rather than spending any more of our panelists' valuable time, I would just limit myself to another administrative remark. I, as a moderator, have been instructed to just introduce our panelists by reference to their current positions. The remainder of their distinguished careers are available on the bios in front of you, so I have been instructed to encourage you to read their bios. So, without further ado, we have as our first speaker, Stromseth. She's Professor of Law, Georgetown University. She's formerly Deputy to the Ambassador at Large Office of Global Criminal Justice at the State Department. And she will talk about assessing the ICC, its challenges and impacts.
Thanks also to American University and the co-sponsors for bringing us together for this very interesting conference. Its focus on the intersection between international and domestic justice efforts, I think, is at the cutting edge of justice and accountability for atrocity crimes. It's the creative space where a lot of innovation is happening and more is urgently needed. So I think it's a great topic that brings us all here together. My focus will be on the International Criminal Court, specifically on the question of how the court's impact should be conceptualized and assessed, especially in light of its ambitious goals and the many challenges it faces. But before sketching out some of the ways to think about the court's impact, including its catalyzing effects on domestic actors, let me briefly highlight 3 sets of fundamental challenges that confront the court and I think have an influence on its impact. First is the expectations challenge. How can the court possibly meet expectations as the culmination of decades of effort to promote justice and accountability for the worst crimes known to humanity? The ICC faces enormous expectations from governments, victims, and survivors, civil society groups, and its own ambitious goals include ending impunity for perpetrators of the most serious crimes that concern the international community, genocide, crimes against humanity, war crimes, and must contribute to the prevention of such crimes. Yet, the ICC cannot be everywhere, and the Rome Statute is designed not to be. Its jurisdiction depends on some form of state consent, absent the UN Security Council referral. Moreover, around 70 countries, including many very powerful states, have not accepted the court's jurisdiction, although some of them still do support the court's work in various ways. Even when the state consent is present, the ICC is deliberately accorded last resort that is complementary to national jurisdictions who have the primary responsibility for taking action to prevent atrocity crimes. And this complementary principle, which we put a lot about today, is not just a limitation on the court. It has real benefits, encouraging justice to be done nationally in directly affected communities, closer to victims. Hopefully, in the process, building up domestic rule of law capacity is the first line of defense against atrocities. But as a result of these gaps, including deliberate ones in the court's jurisdiction, the court is often expected to be, by civil society, by victims, even governments, to be where it cannot be. has no territorial jurisdiction, for instance, currently in Iraq or Syria, where ISIS and the Assad regime are committing egregious, unspeakable atrocities. And situations like this underscore the enormous importance of effective documentation to gather evidence of atrocities that can be used in prosecutions if possible, including before domestic courts in different countries that may have jurisdiction. So those are some of the expectations challenges that the court faces. Second are institutional capacity challenges. Can the ICC as an institution meet its practical demands? Some of these challenges include resource constraints that limit the court's ability to do its work. It has a relatively small number of investigators when you consider the global scope of its mission. It also faces pushback and lack of cooperation by some states, especially as in the case of Sudan and Kenya, when the ICC has gone after heads of state or other high-level officials, leading to issues of witness protection and many other challenges. And also, there are the potential institutional burdens if the court's jurisdiction over the crime of aggression was activated in 2017, which would put additional pressure on the court in its early years. So those are some of the institutional capacity challenges. Third are legitimacy challenges. Is the court looking at Africa? Is there a double standard? The ICC's relations with some African states, especially Kenya and Sudan, are deeply strained for many other campaigns, including the African Union against the court, advancing the narrative of the ICC as biased against them. And to be sure, 9 out of the 10 of the Office of the Prosecutor's formal investigations are in African countries. Although 5 emerged from government self-referrals to the court, 1 followed a series of national declarations accepting the court's jurisdiction, and 2 were referred by the Security Council. On the other side, there's considerable support for the ICC among key African states and African civil society groups. The Central African Republic is working very closely with the court, and the African Union assisted, and also the Ugandan and Central African Republic government assisted in handing over the LRA leader Dominic Ongwen to the court. Furthermore, the leaders of the court, the prosecutor, the president of the Assembly of State Parties are African, prominent Africans, and the ASP president has emphasized the priority of, quote, reconciling the court with all regions of the world, including Africa. It's also worth noting that the prosecutor is just opening the first non-African investigation concerning South Ossetia, Georgia, and also that the ICC's preliminary examinations are more geographically diverse. But there's no doubt that the lack of universality in the court's membership, including great power absence, feeds a perception of double standards. It does make the court vulnerable to a critique of selective justice. And another aspect of this concerns cases against rebels versus leaders. Most of the ICC's early cases focus on rebel leaders rather than state actors. And state actors, governments can often resist cooperation when their own officials are being investigated and prosecuted, and cooperate when rebels or adversaries are being investigated and prosecuted. And that also raises some concerns for legitimacy. So in light of these issues, how should we assess the court's impact going forward? And let me just spotlight briefly 4 ways to think about the court's impact, 4 frames that are interrelated. First and most basic is the court's track record in actually bringing people to justice. It's important to have a successful track record of investigations and convictions through fair and credible processes if the court aspires to actually end impunity and contribute to prevention of atrocity crimes, to actually achieve justice. Yet in the 13.5 years since the court's jurisdiction took effect, it has completed 2 trials, much less convictions. Only 4 defendants that have tried all the way to verdict, 3 of them convicted, 1 acquitted, although there are a number of other cases of training or verdicts that's going to come in the future. Apprehension rates also vary heavily by situation, and for example, all of the defendants in the Dartmoor and Libya situations are still outside the court's custody. So that raises the question, are there reasons to think that the court's record, assuming its fugitives apprehended, its witnesses protected, or bringing its cases through verdict or securing convictions will improve in the years ahead? The court's track record, though, in bringing people to justice is not only a question of successful convictions and behavior, it also involves meaningful outreach and engagement with affected victim communities. It's vitally important to give affected communities communities a sense of a stake in the ICC's work, demonstrating that justice is being done, engaging with them through the ICC's field offices and in other ways. Indeed, seriously wrestling with and engaging with victims about their aspirations and their critiques of the work of the court is important if the court is going to be able to build public confidence that justice can in fact be fair. And there's some interesting research done by a scholar named Stuart Ford, drawing on social psychology research, which suggests that perceptions of legitimacy, not only of the court, but of other tribunals among victim populations often focuses on substantively, are you trying my group or are you trying an adversary group? And so a lot of the question of the legitimacy of the court has to engage honestly in some of these very challenging and difficult issues. And I think a model for this would be the Special Court of Sierra Leone, where there was an effort to go around and do extensive engagement with affected communities and take seriously their very legitimate concerns and critiques about the court's work and engage with the limitations of the court and have those kinds of conversations in a sense of kind of Socratic dialogue about justice, which I think has to happen if affected communities are going to have a sense that justice is actually being done for them. A second way to think about the court's impact is its role in catalyzing domestic action. And here, the different forms of complementarity, Ambassador Rath talked about responsive complementarity, positive complementarity, cooperative complementarity. Ideas here is how can the court encourage genuine domestic action in support of accountability for atrocity crimes? And let me mention a couple elements of this kind of catalyzing impact of the court. One is the impact of the court's preliminary examinations, that is, its initial examinations into a number of potential situations in which crimes within the court's jurisdiction may have been committed. Now, the OTP's preliminary examinations are geographically diverse, including Colombia, the UK, Iraq, Afghanistan, Palestine, Nigeria, and Ukraine. And the Office of the Prosecutor has made very clear that it seeks to contribute to the key goals of the Rome Statute, namely ending impunity and prevention of crimes through the work of its preliminary examinations, thereby potentially obviating the need for the court to intervene, and to do this in a cost-effective way and actually encourage meaningful domestic action. And I think we've seen some tangible examples of this. One which has been discussed by others today is the Colombia example, where a preliminary examination began in June 2004, over 11 and a half years ago, and the current peace and justice negotiations are grappling with some challenging models for alternative sentencing, but clearly there's an active engagement between the Office of the Prosecutor and the negotiators in Colombia on issues of justice and accountability. Another example I'd like to flag is the prosecutor's policy on sexual and gender-based violence. She's made a real focus on this issue, this critical issue, and I think she's let countries know that she's engaged in preliminary examinations, that she's looking at their willingness and ability to prosecute for those kinds of crimes. I think that's another example of the catalyzing impact. Another would be positive or cooperative complementarity and capacity building in situational countries where the ICC has cases underway, such as in the Central African Republic, where there's a kind of cooperative division of labor between the ICC and between the local authorities, including through this emerging hybrid court, which hopefully over time will build the capacity of the national authorities to investigate, do witness protection, prosecute, and adjudicate atrocity crimes, hopefully with larger spillover effects on the domestic justice system. And there are more catalyzing effects as well, and I know Geoff will probably talk about some of these things in the amazing scholarship on this, and look forward to hearing from him on that. A third way to assess the ICC's impact concerns the deterrence and prevention of crimes. Does the ICC affect the calculations of potential perpetrators? This is, of course, very difficult to assess and will depend on many factors, including the nature of particular conflicts and armed groups, and it remains early to say what impact the court is or will have in this regard. But I have no doubt that there are some people alive today because of the deterrent impact of the International Criminal Court. And let me just give you one example. Sister Josephine, a brave Catholic nun in the Central African Republic, was sheltering on the Catholic compound where she and her priest resided, a group of Muslims who were fleeing the anti-Palestinian militias who apprehended several of them, we're going to take them out into the bush and kill them. And she said, you let these people go, this compound is within the jurisdiction of the ICC, and if you don't let them go, you're going to have them paid. And they let them go. So we have at least one example of a deterrent impact that beyond the anecdotes, there's political science scholarship by Beth Simmons and Herman Joe, who present statistical evidence suggesting that some state actors and rebel groups can be deterred, both through prosecution and through broader social deterrents, including the court's ability to mobilize and reinforce a variety of social pressures against atrocities. And they note that actors who are concerned about their legitimacy in the eyes of the domestic public and in the international community are much more likely to be deterred by the possibility of ICC prosecution than those who are not. So there's a lot of, I think, active scholarship, active sort of work to do in this area, but clearly credible, successful prosecutions before the ICC are a crucial part of building an architecture of accountability with interacting roles between domestic and international actors that will help reinforce the prospects for deterrence moving forward. Also important are longer-term efforts of prevention, which include training and professionalism of militaries around international humanitarian law, domestication of the Rome Statute, and so forth. So there are longer-term prevention aspects that can be catalyzed also by the Rome Statute and the court. Fourth and finally, a critical aspect of the court's impact, I think, is the empowerment of civil society around justice. Notwithstanding the limitations and challenges of the court, the ICC has been a galvanizing symbol for justice. Anyone who's been in an Assembly of States Parties meeting in The Hague has to be impressed by the hundreds of civil society groups that gather there, NGOs from all around the world, tables full of reports, documentation of atrocities, side events on topics like justice for South Sudan, Hague Report for Ukraine, documenting atrocities in Syria. The ICC has helped change the terms of discussion, even in situations or countries where it hasn't a jurisdiction. I think it's helped to empower civil society advocates for justice. I think it's very important to encourage and support the work of civil society groups to help reinforce the demand for justice and accountability, bolstering the frameworks in domestic settings that are advocating for justice. Claudia Pazimpas spoke earlier today about the importance of the demand for justice by victims in Guatemala as critical to the successful conviction of U.S. moms. Brody talked about the demand for justice for victims that have been critical in setting up the Hague Court. So I think it's important to consider both the supply side of justice and the building of judicial capacity, but also the demand side of justice is very, very important. Now, just to conclude, the ICC is a very young institution. Its record and impact are only beginning to be established and understood. And looking forward, a central challenge will be how to strengthen the interactive, interdependent efforts to seek justice and accountability for atrocity crimes in the years ahead, how to promote catalyzing synergies between international and national action, with the ultimate aim of strengthening national capacity for justice as the first line of defense against atrocity crimes. Clearly, there are many challenges, many obstacles ahead, but there are also many signs of hope and innovation on which we can and must go.
Thank you very much, ma'am. Now we are moving to talk Buchwald. Is it CH? It's Buchwald. He's a special coordinator at the Office of Global Criminal Justice, and he will be talking about elements of our international criminal justice system.
Yeah, so thank you. And of course, the rest of my introduction is online. The rest of my introduction is online, but it's not very interesting. So thank you, and thanks to you, College of Law, for the sponsors, for the honor to be here, such a distinguished panelists, you, my colleagues here from the office, to join in speaking about the theme of the day, which is building a credible and legitimate international justice system. So I would say most of us here start from basically the same point, that mass atrocities are both not only a world-like, but a threat to peace and security, security strategy in 2010, which said that the innocent community, both the innocent community and the promotion of justice are not just moral imperatives, they're stabilizing forces in international affairs. And I know that many scholars have done some very thoughtful work on the precise links between accountability and the deterrence of atrocity crime or prevention of conflict. And of course, those of us who come into 3 minutes towards the time, so we don't think as deeply. But I think instinctively and through our experience, we share the conviction that's behind what the resident said about the link on the basis of our basically daily experience. So we could have an interesting conversation about the contribution, accountability, deterrence, and prevention. But I think that what we'd rather do is focus on the practical challenge of getting to accountability in the first place. So if we believe that successfully pursuing a measure of justice pays dividends, how do we increase the chances of success? How can our admittedly flawed institutions do this more effectively, more sustainably, more quickly, in a way that makes the promise of justice more credible and reliable? And none of us have all the answers, but I would start with a few things. I'd start by acknowledging that something is often overlooked, that the different the situation is now than it was when I came to the State Department, 25 years ago, aware. And it's a period of incredible evolution in the way we think about the need to prosecute atrocity crimes. And people often, there's a lot of criticism of the court, a lot of people discouraged, but I think it's too easy to lose sight of how far we've come, and discouragement and steps backwards in the greater march forwardness is inevitable. If you think back to just last week with the conviction of Beba, the SEC, the project in the Yugoslavian tribunal, those are incredible events. Those are events that are absolutely inconceivable. Even when the Yugoslavian tribunal was set up, they're absolutely inconceivable. And they're taken now as a matter of course. These are the kinds of powerful figures who, in the past, would have really have virtually no chance of facing justice. These are horrible things. And they were tried in a way that is basically, people have criticisms, it's credible, it was rigorous, it's done in a fair way, it's thorough. When you read it, it stands up to the, it passes the eye test. This is an incredible advance over where we were, and it should not be, that advance should not be ever minimized. The creation of these institutions like the ICC, they reflect what our boss, our code, used to call the upgraded hardware that helps give effect to principles of justice, which Harold would call software, that were developed after Nuremberg, but were created in Nuremberg or recognized in Nuremberg, but then sort of were dormant for half a century. So these institutions serve two purposes. They convict, put away people like corruption, they do justice in that sense, but they're really, in a broader sense, they're the manifestation of ideas and ideals, and they serve as a point around which the international community, large parts of it, can rally, create a broader, Jim was talking about, a broader demand for justice, the principle of those responsible for atrocities cannot go unpunished. Today, unlike 30 years ago, when there was a situation of mass atrocities, it's not everyone, but a huge portion of the international community moves right to the question of how should we deal with atrocities. It doesn't let that sort of basic test, even in a place like Syria, where there's no, there's no way to sort of hold accountable, court people now. The question is on the forefront of people's minds. It's discussed. It's part of the way we think about the entire situation. That's not the way it would have been 30 years ago. The ideas behind the court, embodied in the court, permeate everywhere. I saw a cross-country survey in South Sudan where 93% of people wanted people responsible for cases to be prosecuted. It's unbelievable. This is a sea change in the way things the way the issues come up. But we know there are gaps in the system and things that the existing justice mechanisms can't do or aren't doing well. And James was talking about the limits of what the ICC can move to accomplish while you're there. But you have to remember that even an ICC that was functioning perfectly with virtually unlimited resources, which it will never have, it will still be holes in the system. And places where it can investigate or for whatever reason, it can't possibly catch everything. And if you think about a course situation, maybe like in Syria, even working as designed, it would only deal with a small fraction of cases. And that is helpful, it's useful, it's critical, but it's not everything. So while we have better hardware now than we did 25 years ago, we need to be sort of flexible in the way we sort of think about these issues. We can't think about the ICC as the answer to all problems, because the ICC is good. It plays to what James was talking about, the sort of expectations gap, sort of an unfair expectation of the ICC. But the ICC is really not there to solve every problem the world has, which is the way many people sometimes see it. Something comes up in the news, and around the world, well, that's how the ICC deal with it. What do we need? So what are the other tools? Well, the main tool, of course, is domestic justice, right? Building on domestic justice. And one of the things the ICC does, of course, is create a demand for justice that can be met, not just with the ICC, but with other states. So that might seem perverse, but that's the way, that's in fact the ICC operating at its best. And of course, the Rome Statute itself has a preference for the idea of being before the last resort, presupposes that domestic justice is better. Domestic justice is superior in a lot of ways. National institutions do not necessarily have to be activated by an outside force. They can operate judiciously. They don't require negotiations. They have capacity and independence. They can provide immediate corrective action and antibodies oftentimes. Right, we're going to sort of go through some recent examples of cases where national mechanisms have done quite admirably, sort of stimulated by the demand for justice international that exists. So getting the courts are, there's prosecutions going forward, prosecutions going forward that are maybe contributable to the major international community sees these issues. In the Central African Republic, James talked about in Guatemala, we saw the Arthur's trial, which is, when I came to the State Department, Guatemala was a very different place than it still has lots of problems, but it's a very different place. And, that is part of my brain that was working in the grade administration is incomprehensible. And of course that too built on a lot of sort of outside support and international as well as a robust civil society pushing for justice outcomes. So separately, or another step, additional step after more traditional domestic mechanisms. Of course, we have the models of various kinds of hybrid institutions, which can help domestic jurisdictions fill gaps that exist or make progress towards justice faster, or add credibility, or contribute in various ways to better justice outcomes. Draw quality. And talking really fast now. I should write short little speeches for myself, but I was going to go through some sort of hybrid tribunals, Sierra Leone, and so forth, and Kosovo. But the sum of the story is that the U.S. or the people I work for. So you try to look for ways to support tribunals and sort of mixed mechanisms as a supply chain role would otherwise be guessed. The last topic we were going to talk about, I think, Jason, we're talking about when came in next door was situations where basically sort of at least in the present tense, and like in Syria. And this is, a very frustrating thing for people who work on these issues and for all of us. It just seems there's something wrong and there's something that's not very easy to fix. But we have to sort of think about it, probably we can work towards we sort of think over a period of time that things that Gary was saying inside that has some phrase that the fact that we can't have justice today, we should keep pursuing it, and a lot of the efforts that are being supported within the State Department are meant to promote a result where the paving way for prosecutions down the road, even not knowing that prosecution is being placed, not in Syria, just as time in the Middle East times, it's a great example of that. And in Iraq, which is another place where things are sort of out of control with ISIL and so forth, and think of that in a way that's part of the ICC's expectations of that too. We think of that the secretary spoke about those crimes being committed by ISIL, genocide, humanity, and it conjures up inevitably before the ICC. But really, the problem with ISIL has several steps before you get to the ICC. It's a fundamental problem, security problem in the world today. Is it conceivable that the ICC by itself is deal with that in an effective way? It's a much bigger problem that requires that may have to justice mechanisms like the ICC sometimes down the road with domestic prosecutions in Iraq. But again, it's something that sort of gave way for today. And actually, in Iraq, there is prosecution for several prosecutions in Iraqi courts, and it was in the newspapers this week. You can say that the woman who was responsible for many of the rapes of women in northern Iraq and of Kayla was tried and convicted in her short street. So there's some progress being made there, and I think I better stop you with questions. So thank you very much.
Thank you for saving us discussions time. And now we would move on to Geoff Dancy, who is an associate professor at Tulane University, and his presentation will be on the screen, so it's a positive unintended consequence.
Hi everyone, I'm actually an assistant professor, so don't tell anybody at Tulane that I'm an associate or they might reject me. So I'm a political scientist among a sea of lawyers here. I can always tell when I'm around lawyers because you're better dressed, better looking people. Don't tell them I said that. But I can also tell because the themes aren't quite the same. In political science, everyone says that the ICC is in crisis. So if this were a political science convention, people would be saying, well, it's too expensive, right? It's counterproductive, it gets in the way of peace. This is a neo-colonial institution, and the recent round with the African Union proves that. So I think that political scientists were here, they're going to say, what is the ICC doing, right? And when I look at all this stuff, I'm steeped in all this political science discourse, I think to myself, what are the baselines that we're applying as political scientists? So I'm very curious about that. I'm curious about what the baselines for lawyers are, how are we judging impact, as Jane said, but also how are political scientists judging impact? What are they putting it up against? So what I would say, I would boil it down to something very simple. I would say that in law, political scientists think that you don't deal with unintended consequences of legal interventions. And then I would say about political scientists that they don't deal with the positive unintended consequences of legal intervention. So they like to talk about negative unintended consequences. And so as a thought experiment, me and some of my colleagues, we thought, what are maybe some of the positive unintended consequences, or a room where we might explore some of those positive unintended consequences of the ICC, but also broader judicial interventions in the world. So this dovetailed easily with something that I've been working on for, I hesitate to say, 6 years now, which is collecting a bunch of data on transitional justice in the world. So Catherine Sickink, Lee Payne, some other prominent political scientists, and I, as a graduate student, were suddenly collecting data from every country in the world from 1970 through 2010, criminal trials at the domestic level, truth commissions, amnesties, vetting procedures, reparations policies, and trying to capture quantitative and qualitative differences between countries. One of the things that I thought we could focus on, or some kind of cross-pollination between our projects, is whether an ICC intervention, and maybe that's too strong of a term, but ICC involvement in a country actually increases domestic criminal prosecutions. So that's what we're going to focus on today, specifically domestic criminal prosecution. This is in the realm of positive complementarity. So we had to learn quite a bit about positive complementarity and the theories thereof. I think originally it was supposed to be an effect that was attendant to preliminary examinations at the ICC or at OTP. So when OTP is engaged in a preliminary examination, maybe countries then go about trying to make some improvements to the justice sector so that it can ward off the triggering of ICC jurisdiction. But we're actually thinking that there might be an effect if the ICC is actually in a full investigation in a country, that countries get involved in what we call something like unintended positive complementarity. I'm sorry, I would call it that, or something like reactionary complementarity. So there's a reaction that happens among political leaders in various countries when the ICC is, or OTP is investigating them and sending out arrest warrants. So I'll talk about how that goes. So we think that an ICC investigation increases domestic prosecutions because ruling coalitions are trying to do what we call feigning willingness to abide by international norms, at the same time that civil society groups are trying to call them hypocrites. So this is a very political story. When the ICC is involved in a place like Uganda or the DRC, the ruling coalition, which is the person that runs the country and all of his or her cohort that support them, say, look, we really do follow these norms, and we care about the International Criminal Court, we care about human rights, and we are going to open the way for certain kinds of reforms. At the same time that civil society is really pushing hard for some kind of openings in the justice sector. And so, kind of paradoxically, we think that in that moment, there's a convergence on the agreement that there has to be some kind of litigation at the domestic level. So we're wondering, does this actually bear out in empirical data? This is just a kind of crazy political science idea. Does this actually bear out? So this is kind of the innards of our theory. So we have the ruling coalition of reformers who try to push for justice demands and building capacity, engaging in what we call gap-filling litigation. And so the rulers and the reformers ultimately converge on domestic prosecutions. So what do I mean by domestic prosecutions? I'm going to have to read the definition here. It's any prosecutorial activity that reaches, oh man, it's hard to read, a domestic court after an indictment and or arrest warrant has been issued for cases related to human rights abuses committed by state agents. So it's not necessarily, what we're looking at here is not necessarily the crimes that are under the specific jurisdiction of the ICC, but just general activity putting state agents on trial for things that we would characterize as human rights abuses. So this is why it's unintended positive complementarity, because we would expect if the ICC is involved that the countries might actually put people on trial for war crimes or crimes against humanity or other things that are in the Rome Statute, but maybe they just go after police and security forces for broader human rights violations. And these are the ones that we've counted. We're counters. So we go around the world and we just count these things up. So we think that maybe this is kind of a hard test because we would expect in places like Uganda and the DRC where we know that the ruling coalition has gone after opposition groups specifically and not their own agents. That's something that wouldn't be, I don't think, a positive impact of ICC intervention. But what might be positive is if the government actually yields and allows some of its state agents to be put on trial for human rights abuses. So we're looking specifically at trials of state agents. Is there a relationship between ICC investigations and trials of state agents? Okay, this is the part where I'm going to go through some charts. Okay, so I'm going to try to do it in a way that's not scary, but a lot of people hate this. So it's like taking a shot at the doctor's office, I think. But I think this is necessary to lay the groundwork for some of the baselines, for people that are interested in baselines. So we look at all African countries that have had some kind of mass violence or mass human rights violations since 1980, because we wanted to have years before the ICC existed, all the way through 2011. So we could have some kind of baseline. How many trials are there? How's the ICC affecting these processes? So we ultimately look at all African countries, because at the time that we started this, there had only been investigations in Africa. Now we know that we're moving potentially towards investigations elsewhere, the preliminary examinations in other part of the world. But at the time that we wrote this, there were 6 investigations ongoing in Africa. This was pre-Libya and Mali. So we're updating the data right now to answer the question before it comes up. But we're interested in studying countries that might fall under the jurisdiction of the ICC, and then seeing if the ICC shock actually increases domestic processes. So these are all of the domestic human rights trials that we've coded in Africa. They don't all end in, they're not all fair procedures, and they don't all end in guilty verdicts. They don't all end in verdicts. So this is something that's important to know, but we've gotten reports on something like 800 to 900 total trials over time. And these could be, again, low-level trials of police officers, or they could be trials of security forces. We can talk about how we code the data, but we're counting events in reports and trying to do it in an exhaustive way. This is the complex statistical model, and I'm not going to talk about it. Just know that it exists. I'm going to show you charts instead. Okay? It just proves that there's something going on under the hood, and this is what it is. It's controlling for a number of variables, seeing if the ICC investigation shock has an effect on domestic procedures, on the count of domestic procedures that we might call human rights prosecutions. What we see is that an ICC investigation increases the number of domestic prosecutions by 27% or so, close to 30%. And this is, again, comparing to increases that have happened all over the world, because there is something like a justice cascade, at least, that shows up in our data. But this is saying, is there something that happens when there's an ICC investigation that's over and above the normal justice cascade? The answer is yes, and it's statistically significant. Political scientists love saying that. Statistically significant. Economists love it. Okay, so this shows you the probability of prosecutions, or the increase in prosecutions that happens at different levels of human rights abuses. So at low levels of human rights abuses, and we have ways that we do these kinds of data. This is low levels of human rights abuses. You see that there's still a difference between countries, but at high levels, it's even wider. So the dotted line is just if there's an ICC investigation ongoing, there are more trials at all levels of human rights violations. Yeah. This is a bunch of charts. These show relationships that don't exist. Okay, so this is it dependent on how independent the judiciary is in the country? And is it dependent on aid that's flowing to the country? No and no. But what does seem to have an interactive effect, because we can actually combine in our statistical models different variables and see how they combine to produce even more or less of something. We see that there's a relationship between ICC investigations and the number of NGOs that are operating in the country. It matters that civil society is involved. Everybody's been saying it the whole conference, and I was like, I can't wait to show them my charts. Right? It shows that's true. Okay, there is a relationship. Then, this is all, grand. These are big statistical claims across countries, and it's subject to all the same criticisms that any statistical study is subject to. So we just also show trends in each country. So this is from the Foundation for Human Rights Initiative data on the number of cases that have been brought to them in Uganda. And you can see the vertical line is when the ICC opened an investigation. There's a pretty stark increase that happens. There's mobilization that happens around ICC investigations. That's all this is showing. This is showing the same thing with our data in the Democratic Republic of Congo. Okay, and this is showing you a flat line that happens in a place that doesn't have an ICC investigation. The Republic of Congo, though there have been lots of abuses in the Republic of Congo, and there was actually there were victims that were pushing for something to be done about what were called the Brazzaville Beach massacres or disappearances, right? Nothing ever happened. Even though some NGOs were trying to help local actors get trials moving forward, nothing ever happened. And we think that it's partially because the ICC was never involved in it. At least partially because of them. There was less attention on the Republic of Congo. So, in conclusion, we would say that the ICC potentially has more diffuse effects than these things that we talk about, positive complementarity. Maybe this isn't the true form of it, but it's something that's going on. There are diffuse socio-legal effects to ICC involvement in a country. And it might not be generalizable. So it's important to say that it might not be generalizable and it might not last forever. So this is something that we've shown. There is this shock effect to a country. How long does it last? I can't tell you that. I don't have any idea. But one thing that we are going to do is move towards studying this in the future, as well as looking at it in context with other positive unintended consequences of the ICC existing and operating in the world. So some political scientists, bless their hearts, are doing some of this work, right? And I think that there's some lawyers doing this work too, and we're trying to come together in some kind of synergy to develop ideas about what these unintended consequences might be. James already mentioned Beth Simmons and Hiron Joe have worked on social deterrence. They're showing that there's an effect that when the ICC is involved in some countries, that government-sponsored killing decreases, and so does rebel killing for rebel groups that care about the way that they're perceived. So that's something they call social deterrence. There are also other interesting things like legal mimicry. India, who's always kind of been against the Rome Statute and hasn't ratified, changed its rape laws in 2013, and they just copied the language of the Rome Statute. That's interesting. Why did they do that? It's partially because in Sakshi versus Union of India 2004, they said, India's penal code definition of rape is contrary to the contemporary understanding of sexual abuse and violence all over the world, and they took as evidence of that the definition in the Rome Statute. This is something we wouldn't expect. There's some kind of legal mimicry effect that happens in some places. There's also legal clustering. In some countries that have ratified and begun to implement the Rome Statute, they also at the same time put in their criminal code something that affords universal jurisdiction. This has happened in 5 or 6 cases that we found. Why would they do that? They don't have to do that. It's just something interesting that happens. One of those countries is Burkina Faso. I have no idea why. I'd love to hear if anybody has any ideas. And finally, I think that there's a hand-tying and negotiations effect that happens because the ICC exists. I think we saw some of this in Uganda, and I think we're seeing it in Colombia now. But when Santos from Colombia originally gave a speech to the General Assembly about the special peace jurisdiction, he didn't say anything about accountability. This is in 2012. The September 2015 speech is all about the accountability issue in Colombia. And there's something about tying the government's hands and tying rebel groups' hands when they're actually amid these negotiations because they know the ICC's out there. This happens. So finally, we don't know a lot of things still. We don't know how long this lasts, right? This ICC shock effect. We don't know if it's doing anything good. We don't know what comes of the domestic trials. We just know that there's more activity, like when you step into an embed and there's a flurry of activity, there's something like that that happens when the ICC investigates in a country. And so we're just interested in exploring what those things are, positive and negative. I'd love to hear what you have to say about it.
Thank you very much. Now, last but not least, we have Georgetown, who's director of Human Rights Watch's International Justice Program. He will be talking about the ICC, progress, problems, and prospects rendering justice for the most serious crimes.
Very I just have to say at the outset, I'm standing up, not because I don't want to be near my fellow panelists, but I get so fidgety, I may kick Jane, it's better to say. Really, the outset is to thank the War Crimes Research Office and celebrating its 20th anniversary. I think that the WCRO in all the first-rate reports it has put out that include such valuable I do see in the risk of embarrassing Professor Armiger, I will say that I was her teacher when she worked at the Lawyers to the Human Rights Commission. A lot of what I say can be attributed to her training that I was. But seriously, I was thinking things because it's not that often that we get to step back from the trenches and listen to the words from other thoughtful colleagues and exchange ideas. I'm going to talk, as the moderator said, about the ICC, both positive and some real concerns that I have. First, the good news. I'll look at the good news is that I think it's fair to say it's a wide shared view, but let's articulate that there has been a course correction at the International Court over the last week, and that the leadership at the court, starting with the office of the prosecutor, I think has grappled with missteps that happened in its first decade that created real problems for the institution. In addition to the objective problem of court with this kind of ambitious mandate. And you can see the forms of course correction in part in regard to the strategic plans that the prosecutors issued, in reference to the policy on crimes of gender and sexual violence. And I think you can see this now reflected in the verdict that Todd referred to against Geoff, former Vice President of the Congo, and confirmation of charges against the LRA's Dominic Oliver. So there's been a course correction, and that was necessary, and without that, I don't think that the institution would be able to advance. Now, I don't want to project a sense of complacency in regard to policies and practices at the office of the prosecutor, or chambers, at the registry. I think we need, and certainly civil society will, keep a close eye on maintaining impartiality in application of the road statute and independence of the institution from political pressure. But I think the institution is on a firmer footing, and that is something to welcome and acknowledge publicly. That said, some of my concerns have more to do with changes in the underlying contextual context on the global landscape today. Let me just identify a few of those that will be very familiar to you, talking about what some of the implications could be for the court and possibly some short-term steps to minimize any negative implications. And I'll say frankly, I agree with everything Todd Buchwald said, but I take a little darker view, perhaps, than Todd did in his remarks in terms of the nature of the objective challenges that need to be overcome. First and foremost, everyone here is aware of the political reality that we haven't seen greater division among the major powers than at any time since the end of the Cold War. And what does that mean? It means total impunity today for victims of horrific crimes in Syria, and no immediate or foreseeable the Security Council doing what it should have done and tried to do in May 2015, and that is refer the situation in Syria to the court. It's just not foreseeable, and that has horrible impact, not only in Syria, but in those other non-state parties who are beyond the reach of the court's jurisdictional scope. And I'm thinking of victims of hospital bombings in Sana'a, Yemen, and victims of Shia militia crimes or ISIL crimes in Iran. These country situations, and here's where I'm a little familiar than Todd, I think that the prevalence of those crimes and the total impunity with which they have been committed rips and tears at the human rights and justice narrative in a way that's damaging. I think we've heard people tend to blame it on a failure of the International Criminal Court, when all of us in this room know it is a failure of the will of one or two permanent members of the UN Security Council. I think it's serious obvious. I think we're also aware of the economic difficulties a number of the court's deep pocket state parties are facing, and the policy of economic or financial austerity, which in regard to the 7 largest contributors to the ICC budget has translated into a policy of zero nominal growth in the court's budget for the last year. And what's ironic is that when the demand for accountability is greater, the court's state parties are tightening the financial reach in a way that limits its jurisdictional reach even where it is possible. The prosecutor speaks of her desire to bring a new investigation, not looking at Gaddafi-era officials, but at those responsible for serious crimes since 2011. She cannot do that for financial reasons. The second investigation in Cote d'Ivoire against alleged crimes by the Water side has been hampered because of lack of sufficient financial resources on the side of the This is what zero nominal growth means in practice. And I'm concerned about this. I think there's reason to be obvious. The phenomena that has been very costly where it counts the most for a new judicial institution. The backlash from a handful of African leaders, some state parties, most non-state parties, who are very active in opposing the court because they fear accountability. And I have in mind, of course, Omar al-Bashir, the late Muammar Gaddafi, and the president and deputy president of Kenya, and the president of Uganda, the latter two, of course, being state parties. And frankly, they have seized control of the narrative. And I think they have thrown into question the court's legitimacy. And they've been able to do this either because their narrative has such resonance in centuries of colonial ravages of the African continent with never any incident or intention of accounting for what happened. And I think that's why the Omar al-Bashir and the Uhuru Kenyatta as opposed to international court. Jane mentioned, I think what is a very important positive example, and that is the mobilization of African civil society to speak to the need for justice that they're facing. And I don't want to exaggerate. They haven't wrested control of the narrative from those handful of leaders, but they are a counter voice in their respective countries across the world. So I think that's a challenge for the court and its supporters as well. And then lastly, of course, the refugee flow that has, to my eye, overwhelmed European authorities. And I can say from my own conversations with diplomats in New York, certainly absorbed a great deal of attention on the part of those who would be otherwise focused on policies relating to accountability and the international community. I think that's going to take a long time to work out. Now, positively, I think there are some steps to take. As I said, mindful of the time, I think it's going to be most difficult for victims of crimes beyond the court's jurisdiction in Yemen, Iraq, Syria, etc. I think we've heard today some documentation, absolutely. I also think, with the reference to this morning, the use of universal jurisdiction statutes in countries that have them, where there is a large diaspora community, to identify those who might have been implicated in crimes in Syria or in Iraq. And let's take a page out of the book of the Bosnian conflict and the genocide in Rwanda. How did those prosecutions happen in Denmark and in Norway? They happened because the exile community identified, he wasn't a Rwandan, so I'll say Bosnian Serb, the rights of Duskotatic to authorities in Germany, who became the first accused to appear before the Nazi. So I think that's a way to go. Let me talk about the economic austerity. It is time to throw the old conceptions aside in terms of what the role of the court created. When Francis Fukuyama was writing about the end of history, I'm glad we and announcing the triumph of democratic capitalism at the end of the Cold War, that was the period in which the court was conceived and birthed. And you all know it, and I know it too. We are living and working in very different and more difficult times, and I think it's incumbent on all stakeholders. I mean, state parties, the assembly of state parties, court officials, and civil society organizations like my own, to begin to think outside the box in terms of what role this court needs to play in a very different situation from the one in which it was conceived. I should aim, and I just want to say this, to bring me back to Todd, in the sense that I share Todd's view that the arc of history bends, albeit slowly and unevenly, towards justice. And I think we all, as stakeholders around the court, need to get our heads focused on that. The changes that the court represents are phenomenal in terms of our own human history, and it's going to take a while. We've got to keep our eyes on the prize. So let me stop here. Okay.
before I open the floor, I noticed from the presentations that there are some things that kind of challenge my own perception of international criminal justice, and that is whether we are asking the wrong questions by characterizing this subject matter as a system. Somehow it seems to suggest that there is some sort of systematicity, institutional cohesion, and automatic nature of one thing leading to another. But it seems to me that if we approach international criminal justice as a systemic phenomenon, we may misdirect our attention from what's really important, and that is, for example, whether Geoff said judicial activity increases. Now, and that also leads me to wonder whether we are confused about asking what the ICC does as opposed to what the ICC is for. There's a lot of disagreement about what the ICC is for. Criminal law is a court that tries criminals, but then there are so many other things. And by extension, what international criminal justice does and what international criminal justice is for. I think there too we seem to have very different ideas about what we expect of this particular material. And we also finally, I seem to be tempted to impose some sort of automaticity to things happening as they should. So the ICC has all these nice complex jurisdictional arrangements, and it should do as it's designed to do. And we would like to somehow strengthen the procedural integrity and efficiency of these things. But from the presentations, it's more about kind of moving ourselves from that kind of rigid framework and look at what has been the consequences, intended or otherwise, and what kind of impact the ICC is leaving on the ground. And maybe if we liberate ourselves from this kind of artificial, perhaps, superficially systemic, institutionalized and mechanized point of view, maybe something more fruitful. So more fruitful insights may emerge. But with that, I would like to have something like 15 minutes to exchange your ideas. So I'm going to just invite you to raise your hands and let me take note of several at a time, and then we will just engage. So I have one here and there. So let's take these three first. So, microphone is here.
In East Timor, I used to hang out with a guy from New York who was a defense lawyer. He defended people accused of war crimes and humanity. So, can anybody tell us anything about criminal defense at the ICC or at any of the other typing? Who are the defense lawyers? Where do they come from? What do they do? Who they?
Thank you very much.
I understand that the Rome statute allows for some funding from the UN, and I was just wondering, does the General Assembly have the ability to release the ICC? And what is the situation?
Thank you very much.
First of all, thank you, panels. My name is Kapil, Director of the ABA's International Criminal Court Project. Richard, Jane, Todd, Geoff. Geoff, particularly if you have a chart, that'd be excellent. The question is about reestablishing American leadership in international criminal justice vis-a-vis its relation to the ICC. As David Tolbert talked about previously, there's this inch-gesture and counterproductive activity out of Congress. We have Senate having bipartisan relationship of legislation to create an ad hoc tribunal for Syria, similar House resolution, non-binding resolution. Yet we know that politically and diplomatically, that's even more of a non-starter for Russia, but even for France and UK or allies. So I'm wondering if you have any out-of-the-box thinking about how to of change that narrative here in DC, but also around the country about.
Thank you very much. And of course, I forgot to mention that for those who wish to contribute, including that influence, please. So anyone like to take so defense, budget, and the narrative.
So I think the narrative has changed quite a bit, actually. I don't think it's changed to the point that, we're looking at the very replication of Rome statue around the corner. But I do think it's, I've been, I think these old guys now for the government an awful long time. And, I can remember, doing UN work, UN legal work in the Bush administration. And a lot of, what would, happen, a lot of the expression of what would happen in the Bush administration response would come out in the way it dealt with resolutions of the United Nations. And it's a completely different atmosphere then than it is now. When the, every year there's a resolution of the General Assembly about the ICC, and it is not the United States, beating away at it, and people don't think the United States. We have our little problems, but so does everybody else. And we're thought of as, productive and sort of on the side of right and so forth. And I think that the court itself acknowledges that the United States is extremely helpful to it in a lot of tangible ways. I think probably more helpful than most, probably almost all states parties. And I don't think that goes unnoticed. There's an issue, we have domestic political issues, and it's not really confined to the ICC the way it used to be. Right? It used to be that was the sort of expression of the way some people project maybe in a way management policy. It's not around that. The fact that you have these resolutions, I don't think it means that there's a referral coming around the corner around the situation of Robert Stewart. In fact, you have those resolutions stepping up to it, without sort of anti-ICC rhetoric in there. It's itself a reflection of the way that the ICC has come to be seen in a much more balanced way. I remember a few years ago when the Joseph Cody film came out, and my son, who was right? He would have been 13, and I came home from work one day, and they'd seen it in school, and you work with the ICC, right? And I was like, here, all of a sudden, I didn't know, you never heard of it. Before you heard the initials to his mother, to my wife. And, in the period leading up to the Rome Center, there were a lot of people who were looking at the ICC in a very sort of abstract way, seeing dark corners and so forth. And, it's not at all that Rome Center hasn't really sort of operated in that way. And I think that what's happened is people, see, sort of like what happened in Sarajevo. People have all kinds of mixed feelings about a lot of things. You see a bomb go up in Sarajevo. Americans across the board want the bad guy to be punished, and they see Joseph Cody. They want the bad guy to be punished, and they've come to see the ICC more in that light, not completely, but more in that light by a lot than it used to be. So I think that the situation is much, much better than it used to be. Notwithstanding that it's not perfect, and the fact that we're not parties can be sort of used to sort of count against us. On the funding question, it's a complicated question. I think the issue usually comes up in many states parties, especially want the State Security Council to pay for the cost of the SEC incurred in putting this firm. And I think there are their own domestic problems with that. But I think sort of more fundamentally is it's not that issue is not an issue really confused with the ICC. The issue relates to the way the UN deals with entities that it authorizes to do action, right? So, for example, if the Security Council thinks that there's a peacekeeping mission needed in Canada, wherever it is, and they set up a UN peacekeeping mission, which is to say a peacekeeping mission that reports to the Secretary General and so forth, well, if there's assess costs and it comes from the budget, and comes out of assessment to the states, the UN. But when the UN authorizes somebody else to do peacekeeping in Canada, it authorizes the United States to do peacekeeping in Canada, or it authorizes the United States to do, or NATO, to do military campaign in Libya, it's the last thing that even comes to mind that the UN should pay for. You know, that's the difference. It's not a UN operation, it's an independent body that's actually, even though it draws legal authorization from the UN. And I think some people, some of the state parties, look at just the cost that they're incurring and say, well, the UN should pay for it, they created this cost. And then some people sort of see it from a UN point of view, the way the UN budget normally works, saying it's different than the way any other organization would be, no other organization would get funding from the UN just because the UN gets it made it legal for them to do something. And I would say in the case of the ICC, particularly, the idea that the UN, the idea that the UN would pay because if for a case, part of the sentiment of that is that we're incurring this cost, right, to do this thing. But it's not the same thing as when a non-party accepts the jurisdiction. Nobody asks Cote d'Ivoire to pay for the cost of the security forces, right? There's a cost that could be created and acted by somebody not paying anything at all. So I think it's actually, but the general sentiment of the UN itself are not number three of the budget.
For political reasons, the UNDRA would not be able to act, or is there actually a legal bar?
Well, I mean, the other does what the other does, and it operates the votes. I think we would say that it's not a problem.
Perhaps the other panelists can introduce this conversation.
Just a couple of things about the U.S. relationship with the ICC. I think the U.S. has supported the ICC's work on a case-by-case basis in a number of very tangible ways. Through the War Crimes Rewards Program, you can pay rewards to get suspects before the ICC. We assisted in getting Oslo and everything from the conflict to the ICC, working very closely with the court. And so there are some pretty significant ways in which the U.S. has done work that the court would acknowledge is very valuable. There might be some possibility to provide funds, perhaps through the trust fund for victims. And that's at least something to think about. Could the U.S. contribute funds to that mechanism? Another thing, Kip, in response to your question about an accountability narrative, is the effort, which I would encourage, to try to develop a domestic crimes against humanity statute, which would be, I think, quite valuable to look in that direction. So there are a number of very concrete initiatives, but I think Todd's right that if you take the narrative over a long period of time, you will see, I think, a significant change, a significant positive trajectory, which hopefully can be continued going forward.
Couple of thoughts, briefly. First, with regard to William's question about defense lawyers, I think it was a serious omission in the Rome statute drafting process that there was no formal provisions made for the defense bar. There is a roster of defense attorneys who are available. There is also an office for criminal defense in the court available to indigent defendants. So absolutely nobody appears in the courtroom at their initial hearing is without the services of a qualified attorney or an attorney of their own choosing. And as I said, there's a roster. I think work needs to be done to really bolster that, so that arrangement is likely to afford the best quality defense representation possible. On the UN funding, of course, the ICC is a separate and independent judicial entity that has no formal organization tied to the United Nations. Of course, it's distinct from, say, the International Court of Justice. I think it's correct that the General Assembly does not have the basis to provide funding. I can tell you what damages U.S. government standing in reform is what is perceived to be the U.S. government's inability or unwillingness to move forward on allowing UN funds to support the burden the court shoulders when the Security Council has tasked them, as it has in Darfur and as it has in Libya, to investigate. My own view is, I think it's a political question. I understand the political undertone, but a legal undertone. And Kip, yeah, I share what Jane said. I remember the first Assembly of State Parliament meeting in the 2009 when the Obama administration had just come into office. I thought there were representatives from every U.S. government agency other than the Food and Agricultural Department. I mean, it was quite a crowd, and Stephen was there, he was there for every other one after that. And I think there has been an important positive trajectory that the U.S. government is playing, and I think that needs to be acknowledged. One point, and that is, I saw some of this, or the foundations for some of this, take shape in the last years of the administration of Georgetown, where to the Bush administration credit, Todd, who were involved in that, the U.S. played a firm role in regard to Sudan and the prospect of the Security Council granting a one-year suspension to proceedings directed against Sudanese accused. The lesson I draw is that an outgoing administration, not that they did this deliberately, but an outgoing administration can politically create conditions that make a succeeding administration politically more able to act on its important vehicle before the Obama administration was in office. Some public steps are taken that will enable the next administration to act with even more political courage. The last point is, I think the demonstration of support would be to call on the government of Iraq to accept the jurisdiction of the court to handle war crimes and crimes against humanity, perhaps genocide. That would be a commitment demonstration of extending the reach of justice to a country otherwise beyond its scope.
Thank you very much. We have just hit the 50 mark, so at least I should declare this session complete. But if you have time to ask questions, I hope you can grab our panelists on our way to the other conference room and ask them the questions you want to ask. But otherwise,